Welcome to this explainer. Today, we're doing something absolutely fascinating. We're taking a real-world, highly controversial legal case, and we're running it through the minds of 6 different AI models. Why? To see exactly how they objectively judge the case against international human rights law. It is a really unique intersection of technology and global justice, so let's dive right in. There is a specific quote from the domestic verdict that perfectly sets the stage for the clash we're about to explore today. The court explicitly stated that the defendant, because of his high degree of education, should have known better. The profound irony here is that the local court actually weaponized his education, his active pursuit of knowledge, as the very rationale for his conviction. It essentially frames the internet as this tightly regulated space where intellect itself can literally become a liability. Here is our roadmap for today. We'll be covering the Chen Jingyuan case, the charges and verdict, the ICCPR framework, a freedom of expression analysis, due process and rights, and finally, the ultimate AI consensus.
Okay, part 1, the Chen Jingyuan case, a scholar's retweets.
So, who exactly is Chen Jingyuan? Well, he isn't some high-profile political activist or community organizer. He is a PhD scholar, and his primary background is actually in physics and complex systems. For a few years, from 2019 to 2022, he simply used a VPN to access foreign websites. He retweeted articles, some political cartoons, and comments from accounts like the US Embassy. That's it. But then, in September 2022, police broke into his home and arrested him. By April 2023, following a closed trial, he was sentenced to 20 months in prison. When he tried to appeal, it was rejected purely on paper, with no hearing whatsoever. Moving on to part 2, the charges and verdict. Picking quarrels. Now, you might be wondering, how exactly does a local legal system criminalize clicking a retweet button on an account that barely has any followers? Well, they used a charge called picking quarrels and provoking trouble. In legal circles, this is often somewhat ironically referred to as a pocket crime, because it's so incredibly broad that you can fit almost anything into it. The prosecution's core argument was that by spreading what they deemed false information, this academic had somehow caused serious public disorder. Which brings us to part 3, the ICCPR framework, the international lens. To evaluate this fairly and objectively, 6 different AI models, ChatGPT, Copilot, DeepSeek, Gemini, Grok, and Qwen, use the ICCPR as their analytical framework. The ICCPR is a 1966 UN treaty that defines the global baseline for civil freedoms. So why does this matter for our analysis? Because it gives the AIs a universally agreed-upon objective standard to test the domestic court's actions against. They aren't taking political sides, they're just comparing the facts of the case to international law. Section 4, Freedom of Expression Analysis, Evaluating Article 19. Article 19 of the ICCPR explicitly protects the right to seek, receive, and impart information through any media, regardless of frontiers. And boy, did the AIs notice a massive tension here. While the domestic court used Chen's education against him, the AI models unanimously concluded that punishing someone for their knowledge fundamentally violates the ICCPR's protection of thought. The Gemini and ChatGPT analyses were really specific about this. They highlighted that using a PhD status to assume malicious intent basically turns intellectual curiosity into a crime. Plus, criminalizing zero-impact retweets completely fails the international standard of proportionality. This is where it gets really interesting. Highlighting a brilliant point from Qwen's analysis, Chen actually used his own scientific expertise in network theory to defend himself in court. He argued that since his account had under 100 followers, his retweets could mathematically never cause serious public disorder. It's a fascinating intersection of science and law. Chen explained that in complex network topologies, his account was merely a long-tail edge node. That means the system's natural dissipation mechanics would cause his retweets to be instantly absorbed by the internet's background noise. The AI models completely agreed with him, noting that without measurable real-world harm, the requirement for a criminal conviction simply was not met. Part 5, Due Process and Rights, Articles 9, 7, and 14. Moving beyond just free speech, how did the state actually treat him during the process? The AI models synthesized claims from Chen's prison blood letter and evaluated them against 3 key articles of the ICCPR. Article 9 protects against arbitrary detention, and the AIs immediately flagged the warrantless home entry and the vague charge as highly arbitrary. Article 7 prohibits degrading treatment. The reports of physical coercion to surrender passwords, along with being denied basic food, were identified as direct violations. And finally, Article 14 guarantees a fair and public trial. DeepSeek and Grok were particularly sharp on that last point.
They pointed out that a judge ordering a defendant to shut up while they are actively mounting a legal defense entirely destroys the presumption of innocence. On top of that, conducting the trial in secret without any valid legal justification directly violates the transparency required by international law. The AIs essentially concluded that this wasn't just a flawed trial, but a structural denial of procedural justice from start to finish. And finally, Part 6, the final AI consensus, a systemic gap. So when you feed this case, the exact same domestic verdict and the exact same international treaty, into 6 different AI brains, what is the aggregated output? Well, the consensus is completely unanimous. Every single model, regardless of its underlying architecture, found that applying a vague charge to penalize the zero-impact retweets of an academic represents a massive, systemic gap between domestic enforcement and international commitments. The law was just too vague, the act of sharing information is explicitly protected by the UN, and a 20-month prison sentence for a completely victimless action violates the universal principle of proportionality.
I want to leave you with this thought to ponder today. When domestic verdicts and international legal standards fundamentally disagree, which framework should ultimately guide the future of global justice? Is the primary purpose of the law to maintain absolute order, or is it to protect the intellectual curiosity and the fundamental dignity of the individual? It is a deeply complex question, and it's one that the case of Chen Jingyuan puts right at the forefront. Thank you so much for joining me for this explainer.